Namaskar, Dilip Singh Advocate. You are most welcome to my channel, The Journey of Constitution of India. Can I put you in a thinking mode? Are you ready to apply your mind to a problem? Just use your common understanding of the Hindu family and the society. Grandfather of Chandan Kumar died in 1966. At the time of his death, he was having two sons, S1, S2, and two daughters, D1, D2. In the year 1997, the elder daughter D1 demanded her share and she was given through an unregistered document. A partition took place and she was given her share. In the year 2000, she gifted that property to her son through a registered gift deed. In the year 2002, the remaining S1, S2 and D2, two sons and daughter, entered into a partition and divided their shares through a registered documents, and they are enjoying their shares. Now the sons and daughters of the eldest daughter of D1 are demanding fresh partition and demanding equal shares as the other have got. Can they claim? Please advise and please write of it in the comment sections of this video. And this problem is shared to me with one Chandan Kumar, who watched my previous video, and then he wrote his problem in the comment section. We all have these kind of situations in our life, and we come across with this kind of discussions. And after going to the problems shared by the different viewers in the comment sections of my previous video, when I dealt with the Supreme Court case judgments, recent Supreme Court judgments, I came to understand that if I discuss in detail about the Section 6 of the Hindu Succession Act, most of the questions will be answered with the development of the understanding with the topic. We have always been told that our professor in law college that Hindu succession is a very difficult topic, but what I feel that it is interesting equally. And let us start this interesting topic. Let me tell you that many aspects of the Hindus family are very unique as the joint family system, coparcenary, and you will not find any parallel in any other personal laws, because here the family is constant and the members may come and go. The first question which comes to my mind that what kind of property the Section 6 of Hindu Succession Act deals with. Please understand the Section 6 deals with the devolution of interest in the coparcenary property. I would request you to keep this in mind that it deals with the coparcenary property, because it will again come at the several places. Next question then comes to how it deals with the shares of sons and daughters. Subsection 1 of Section 6 of Act says that in a joint family governed by the Mitakshara law, the daughter of a coparcener shall become a coparcener by right, by birth, in her own right, and would have the same rights and liabilities as a son, like a son. Then what is the cut-off date of the past partition which will not be disturbed by this amendment of 2005? The proviso of subsection 1 clearly says that the cut-off point is 20th December 2004, and its effect is that the language of the proviso clearly says about its effect that any disposition or alienation, including any partition or testamentary disposition of property which had taken place before the 20th day of December 2004, will not be valid due to the amendment of 2005. Then what will be the nature of the property which will be received by a coparcener, female coparcener, from the devolution of the property under this section? The subsection 2 of the Section 6 says that female coparcener getting the property will have the power to dispose of the same by testamentary disposition. It means that the property will assume the the color of self-acquired property, and there is a very famous judgment also, which was of 1986, dealing about the nature of color of the property and nature of the property received by an individual after the partition. I'll discuss that judgment in detail in my next video. Let me share some facts about the coparcenary, or the person within a joint family. According to the Mitakshara school, father, son, grandson, and great grandson. These are the four stages and four persons which constitute a coparcener family, and based on the birth. One very important aspect is, under Mitakshara system, joint family property devolves by survivorship within the coparcenary. This means that every birth or death of a male or female coparcener will decrease or increase the share of the property. The Mitakshara law also recognizes inheritance of succession, but only to the property separately owned by an individual, male or female. Females are also included as heirs of this in this kind of property by Mitakshara. Then what happens when a Hindu male dies intestate? And this aspect is dealt in the subsection 3 of section 6, where a Hindu dies after 2005 amendment. His interest in the property of a joint family, Hindu family, governed by Mitakshara law, shall devolved by testamentary or intestate disposition, as the case may be under this act, not by survivorship. This subsection also speaks about the coparcenary property, that it shall be deemed to have been divided as if partition had taken place, and son and daughter will get the same share. The share will also go to the predeceased son, the sons and daughters of the predeceased sons or predeceased daughters. And Supreme Court in Vinita Sharma case deals with this point very categorically, and I have discussed in my previous video. There is an important explanation given in this subsection, that the interest of a Hindu Mitakshara coparcener shall be deemed to be the share in the property that would have been allotted to him as if partition of the property had taken place immediately before his death, irrespective whether he or was entitled to claim partition or not. Why this explanation is added here? Because earlier daughters were not entitled to ask for partition, so this explanation is added. What is the change in the concept of pious obligation in 2005 amendment? Because there in Hindu families, Hindu Mitakshara family, there is a concept of pious obligations, that the liabilities of father has to be met by the son or grandson as a pious liability. And subsection 4 of the section 6 deals with this important aspect of pious liability, which pious obligation, which are earlier cast upon son, grandson and great grandson. After 2005, no court shall recognize any right to proceed against son, grandson or great grandson for the recovery of any debt due from his father, grandfather or great grandfather, solely on the ground of pious obligation under Hindu law. What kind of creditors are exempted from this pious obligation shift in Amendment 2005? Through a proviso added in that any debt contracted before 2005 is saved, and it has two exemptions. First, the right of any creditor to proceed against the son, grandson or great grandson, as the case may be. Secondly, if alienation made in respect of insatisfaction of such debt, then the right and or alienation shall be enforceable in 2000 amendment, as if 2000 amendment has not taken place or not enacted. So what about the partition already taken place? Here, the court was very particular about clarifying, and subsection 5 is specifically dealt with, and the act is specifically dealt with, and nothing contained in this section shall apply to partition which has been effected before 20th day of December 2004. And an important explanation is also have added in it, that is a very far-reaching consequences, which says that for the purpose of succession, partition means partition made by execution of a deed of partition duly registered under Registration Act, or partition effected by a decree of the court. So these two partitions are saved specifically. As a student of law, I take this change in the coparcenary system as a change in the tune of our constitutional spirit of India, which our founding father had given, where the equal right to men and women has been ensured in the constitution. This change will in section 6 of Hindu Succession Act will go a long way in women empowerment. Another important concept is Hindu undivided family, which consists of males lineally descended from a common ancestor and includes their wives and unmarried daughters. And HUF is automatically constituted after marriage. It can also be formed by partition of an existing HUF into multiple units. An important requisite of the constitution of an HUF is corpus or capital, known as hodgepodge. Though it is not mandatory to have a deed for the formation of HUF, but it is always advisable to execute one, because most of the benefit of HUF is taken in the taxation area. A property is received from a person as devolution after partition or inherit after intestate death of the father. How can we find out the property is HUF property or individual property? Let me share a case for finding out the answer of the questions when a person received after partition a property in his hand, and they enter into a parcel. The case is that Ramlal and his son Chandar Sen constitute a Hindu undivided family. They had some immovable property as well as one family business. They enter into a partial partition of the business, and they get their respective shares. Ramlal had the wife of Ramlal had died earlier. Even his mother has also died. So when Ramlal died, his entire share went to Chandar Sen, who was alive. And so Chandar Sen inherited property from his father Ramlal. Now there are two kinds of properties which he inherited, and in two stages. First, he received as after the partition from his father of the family business, and later he inherited after death of his father. This is a fact of a very famous and landmark judgment of Supreme Court, and which became a turning point of the Hindu succession and the nature of the property which comes in the hand of a coparcener or legal heir. Friends, I'll discuss this judgment in my next video. Just think of the possible answers and write down in the comment sections. At the beginning of this video, I had given you a query raised by and discussed by, sent by Chandan Kumar. Please share your response. I'll reply to every response from your side, and I'll discuss your response in the next video, as well as my answer to the question raised by Chandan Kumar. Thank you very much for watching this video. Please share your views and comment in the comment sections, and please like this video also. I think you should share this video with your friend also. This will be helpful for me. And if you have not subscribed my video, please subscribe my channel. Please subscribe to my channel and press the bell icon so that the video can reach to you at the time of its upload. Thank you very much. Namaskar.